Hi guys, welcome back to Nairobi Legal Insights. In our video today, we're going to be discussing about vitiating elements of a contract. Now, in the previous videos, we've discussed the elements of a valid contract. So we need to have a proper understanding about the distinctions between elements of a valid contract and vitiating elements of a contract. These are factors that can make a contract either void or voidable, and we're going to be discussing each one of them so that you understand them much better. Just to take you back where we started before discussing about vitiating factors, we have a checklist that states the different elements that will actually make a valid contract. Now, there is a distinction between an agreement and a contract. Remember that not all agreements are legally enforceable contracts, and as you can see, an agreement is made up of an offer and acceptance, while over and above these two elements, when it comes to a contract, we will have elements such as consideration, intention to create legal relations, capacity, and all the different elements of a valid contract that we discussed in our previous videos. So you need to note that there is a clear distinction between an agreement and a contract. Now, as far as this video is concerned, we're going to be discussing the vitiating factors. These are factors that will actually make a contract that was previously valid into one that can actually be avoided by the party. So one of these factors is mistake. So we have mistake, we have undue influence, we have misrepresentation, we have duress, and we're going to be discussing each of these factors so that you understand them. Basically, you can have a valid contract, but when these factors come into play, that contract can be avoided. As far as grounds for avoiding a contract are concerned, those are the things I've just listed previously. And as you can see, we have misrepresentation, duress, undue influence, mistake, like we stated earlier. And the overall objective of us discussing vitiating factors is for you to understand that there are procedural issues that affect validity of an otherwise valid contract, meaning that you may have a valid contract, but because of these procedural issues, then you're going to end up with a party who is part of the contract avoiding that particular contract. Now, once these things happen, the vitiating factors, then you're going to have a contract that can be avoided by a party. And this can be either one party or both parties to that particular contract. Having mentioned some of the vitiating factors, I want our focus to shift to each one of them so that we understand them much better. As you can already see in this slide, we are focusing on a common mistake, which will create an impossibility, meaning that if you had a valid contract existing and there is a common mistake, this is a vitiating factor, then it is going to be impossible to actually enforce this contract. So what will happen is that parties can actually avoid this contract. As far as a common mistake is concerned, both parties to a contract make the same mistake. So here you have the right intentions, and an example would be that if person A is selling a car to person B, and person A happens to have given out that car that is selling to his mother before this transaction, and they go ahead to sit and agree with person B that this is the car you're buying. Remember, the mother to person A has that car. As you can already see, these parties, meaning person A and B, have the right intention to actually have this sale. But in essence, the car may not exist because person A's mother was probably involved in an accident and that car crashed. In this particular instance, the subject matter does not exist. So this is a common mistake. Much as both parties are actually having the right intention to conclude this transaction of selling a car to person B, the subject matter does not exist. This becomes an impossibility. It is a common mistake for both parties. A common mistake can also arise in circumstances whereby the seller has no title to actually pass that property to the buyer. An example would be that if Rogers is trying to sell a car to Mark, remember Rogers is not the legal owner of that car, meaning that the logbook is in his father's name. In this particular instance, this is a common mistake, and it makes it makes it actually impossible to enforce this contract because it becomes a void contract. Rogers has no legal title to that car he is trying to sell to Mark. Remember that even if a contract is valid, it fulfills all the elements of a valid contract, and then we have a mistake or a common mistake occurring, then that becomes an impossible contract to enforce. It is actually a void contract because of this vitiating factor called mistake. Before we discuss the other vitiating factors, I want us to take note of two key things. These are terms of the contract, which could either be express terms or implied terms. And I want to use this opportunity to give you the distinction between an express contract and an implied contract. When we talk about an express contract, what we mean is that the parties intend to contract and they agree on the explicit terms of that contract. An example would be that if you're getting an internship, that contract you're given is an express contract because it states your duties, your roles, and how much you're going to be paid. Everything is actually put out there for the parties to understand. That is what we call an express contract. On the other side, an implied contract, as far as it is concerned, the parties do not formally agree, but their words and conduct will actually indicate the intention to create a contract. Just to give you an example here, so that again you understand this much better. Suppose every Sunday, for 3 months, Mina asks John to water her plants, and John, being a hardworking guy, waters Mina's plants every single Sunday for those 3 months. Then when the 3 months are done, John goes ahead to water Mina's plants for 6 more Sundays, and every single time John is paid. Now, when John goes over and above these 6 Sundays, on the 13th Sunday when he comes to ask for his money, meaning that he actually continued to prolong the transaction of watering Mina's plants, this time when he comes, Mina chases him away, and Mina tells him, look, I never actually contracted you to water my plants. We have no express agreement. Now, in this particular instance, even if there is no express agreement or express contract or anything written down, the conduct of the parties, meaning that Mina and John, their conduct actually indicates an intention to create a contract. Because even after the 3 months, John worked for 6 more Sundays where he was paid. He continued showing up. Now, even if Mina chases him away, saying that she never contracted him, the court will actually look at the situation and the circumstances, which clearly indicate that there was an intention to create a contract, and that contract will be termed as an implied contract. So please take note of these two different terms, but I've used these terms of a contract to extend them so that you understand the distinction between an express and an implied contract. Now, as far as terms of a contract are concerned, remember that you can have a contract with key terms stated, and in case a party breaches these terms, then of course loss, someone suffers. If you enter into a contract where you're supposed to clean someone's compound, and maybe they're supposed to pay you for the work you do after every cleaning, of course if they don't pay you, they are breaching one of the terms of the contract, which was payment in exchange for your work. And some of the remedies for breach of a contract, or rather breach of a term of a contract, could be withholding performance. Maybe if I've been cleaning your compound and you stop paying me, then I can stop cleaning that compound. That is called withholding performance. They can also be termination. I've employed you to do something for me, and you don't actually do that. Maybe I employed you to water my plants, and you're not watering my plants. I can go ahead to actually terminate the contract we have because you're breaching one of the terms of that specific contract. The other thing is that if someone breaches a fundamental term of a contract, then they can pay damages. Yeah? Maybe I tell you to supply to me 40 crates of eggs on a specific date, and you don't abide by that date, which was so critical as we entered into a contract. That will be considered a fundamental breach, and because you didn't deliver, then maybe my clients suffered as a result of you not delivering those eggs, and you'll be forced to pay me damages. We can also have a remedy of specific performance. Courts can force someone who entered into a contract and is not fulfilling his obligations to actually do what exactly they intended to do when they entered into that specific contract. So take note of these remedies for breach of terms of the contract. This is the most critical part of this video, and I want us to have an overview of the different things we've discussed about today. Now, we talked about terms of a contract, and I used that opportunity to give you the distinction between an express and an implied contract. We went further to talk about breach of terms. Remember that if terms of a contract have been breached, someone actually has, if you've suffered a loss, then someone has to remedy that loss. And we discussed about the remedies that are there for breach of terms. Furthermore, we talked about the grounds for avoiding a contract. These are the vitiating factors. These are the elements that could vitiate a contract, and they included misrepresentation, duress. As you can already see, we discussed these already. And I also want us now to break each one of them so that you understand them much better. Now, when we talk about duress, what we mean here is that if one party makes an improper threat that causes the victim to actually enter into a contract, in that particular instance, the victim has had no reasonable alternative, and in this particular instance, the contract is voidable. If someone has actually forced you into that contract, there is a threat, maybe a threat to your life for you to enter into that contract. This will make the contract voidable. Now, the other thing I want us to understand is the vitiating factor of misrepresentation. Now, as far as misrepresentation is concerned, someone will actually make a false statement to induce another person to enter into a contractual relationship. So, misrepresentation renders the contract voidable at the option of the innocent party. Maybe you go, you're trying to rent out a house, and someone is telling you, we have enough water in this place, there are no mosquitoes, there are no insects, there are no rodents in this area. But when you enter into that house, you actually find out it is infested with pests. Now, the person induced you to enter into this contract by actually giving you these expectations about that particular house. In this particular instance, that contract becomes voidable at the liberty of the innocent party. Now, the other thing I want us to have at the back of our mind is, as far as undue influence is concerned, we can have instances whereby the injured party, as far as this is concerned, will rescind a contract. And as far as rescinding a contract is concerned, someone will actually need to show that there's a special relationship of trust and improper persuasion. An example would be a pastor telling you to transfer your land into his name. That will be undue influence, because you see, people tend to trust their pastors, their priests, their sheikhs. So if a religious leader convinces you maybe to give away your property in form of offertory and tithe, that will be undue influence. And so that contract will be considered voidable. So you need to have that at the back of your mind. The next thing I want us to appreciate is that when these things happen, there will be an impossibility created. Even though the contract was valid initially, it can actually be avoided by a party that entered into that specific contract. Now, remember to have a clear distinction between elements of a valid contract and vitiating elements of a contract. Once you hear the word vitiating, just know these are things, these are grounds for avoiding a contract. They include duress, undue influence, misrepresentation, mistake, and everything we've discussed today. Have that at the back of your mind. Thank you so much for watching, and do not forget to subscribe.